Good day everyone, I am Bianca. Today, our group will be presenting a landmark case in Philippines media law, MVRS Publications Inc. versus Islamic Council of the Philippines. Decided by the Supreme Court in 2003, this case is highly significant because it tackles the delicate balance between the two major things: freedom of expression and the protection of a group's collection reputation. The whole issue started when a local tabloid published an article that many found deeply offensive to the Islamic faith. This sparked a legal battle over whether or not you can actually sue someone for libel when the statement is directed at a massive broad group of people rather than a specific individual. So, in this presentation, our agenda will walk you through the facts of the case, how it traveled through our courts, and the ultimate ruling of the Supreme Court regarding group libel. Let's get started. To give you a quick overview of the case profile, the ponente of the Supreme Court Justice who wrote this decision was Justice Jose N. Bellusilio. In terms of its legal nature, this reached the highest court as a petition of review and certiorari of a decision of the Court of Appeals. As we mentioned, this case really centers on the delicate balance between two fundamental rights that often clash in the media world: freedom of the press on one side and the individual or group's right to reputation on the other. The core legal question our presentation addresses is this: if a defamatory or highly offensive statement is directed at a very large indeterminate group, in this specific case, all Muslims, can that statement legally be used as a basis for a civil action for damages? In other words, can an entire religious community sue for libel when a publication insults their group as a whole, even if no single person was individually named or singled out? To understand how the Supreme Court answered this question, let's take a look at the actual facts of what happened.
The Bulgar article. On August 1, 1992, the daily tabloid Bulgar published an article in its Kuru Kuru section. The piece was written by Agustin Pinegas Jr. and touched upon Islamic beliefs regarding animals, specifically pigs. The disputed content: ang mga Muslim ay hindi kumakain ng baboy, maski na sila ay gutom na. Itinuturing nilang Diyos ang baboy at sinasamba pa nila ito. The compliant. The Islamic Dawah Council of the Philippines, or IDCP, along with the several individual Muslim leaders, filed a complaint for damages to the RTC of Manila. They argued that the article was insulting and damaging to Muslims, published with intent to hurt the feelings and disparage Islam, a violation of Article 26 of the Civil Code. And here are the parties that involved: the petitioners, respondents, and the objectives. For the petitioners, the MVRS Publication Incorporation, Mars Lakansay, Mayla Aguha, and Agustino Benegas Jr., the publisher and the editors. While the respondents, Islamic Dawah Council of the Philippines, IDCP, and individual Muslim adherents. On the objective, respondents sought moral and exemplary damages for religious defamation.
So, the RTC decision: dismissal of complaint. So, the trial court, or the RTC branch for Manila, dismissed the case on June 30, 1995. So, the reason is the article did not identify the plaintiffs specifically. Libel requires the defamation to be directed at a particular person or an identifiable group. So, this only means that the court dismissed the case because the article did not name the people involved. So, Libel only applies if it is targets a specific person or a group. The CA reversal. The Court of Appeals reversed the RTC decision. So, there are three findings. So, the first one is the article was libelous as it targeted all Muslims. Second is the class suit was proper because of a common religious belief. And third is awarded IDCP 50,000 in moral damages. So there are three issues for the Supreme Court. So the Supreme Court will answer three questions. If the article named a group, if a whole religion can sue as one, and if this damages press freedom. So there are four elements of libel. So the first one is imputation, publication, malice, and the identification of the person libeled. So imputation of a crime, vice, defect, or status tending to cause dishonor. So imputation means that, or it says that something that shames or dishonors someone. Publication means communication to a third person. So it was shared or seen by other people. The third one is malice. Malice is that intent to injure reputation, or it was meant to hurt someone's reputation. The third one is identification. The fourth one is identification of a person libeled. The victim must be identifiable to the readers. This is the crucial element in this case, because readers must know who is being talked about.
Group libel, defamatory words directed on a large class or group are generally not actionable by an individual's member. The exception, unless words specifically point to a particular member or a group small enough that every member is identifiable. So, um, group libel is a defamatory statement aimed at a group defined by race, religion, nationality rather than a named individual. Historically, some states made it a crime, arguing it could incite unrest. Today, it's almost impossible to win a civil suit for it is the US. Example, a blog post claims all members of Riverside Church are tax cheat no single person named, so the group is a whole can't sue for libel in most US courts. Next is the essay decision. The essay decision petition or granted a CA decision reverse RTCA dismiss reinforce. The Supreme Court held that individual Muslims have no cause of action because the article was directed of Muslim community, millions of people. So the essay decision, this refers Supreme Court ruling that set the modern standard for libel. Cases are Buhamas versus Leones, 1952, which upheld a group libel law, New York Times v. 1964, which made it much harder for public figures to win libel suits by requiring proof of actual make post claims essentially did in federal law. Next example, after Sullivan, even if newspaper print a false claim about a group of police officers, they have no proof the paper knew it was false and published it anyway.
for groups that bar is particularly impossible. The next is failure of identity. Failure of identity is this is the legal reason group libel claims fail for defamation suit. The plaintiff must prove the statement was of the concerning them, especially if the statement about large group, no individual can show it referred to them. Personally court call the failure of identity. Example, if an article says all lawyers in the Chicago are dishonest, no single lawyer can sue because already wouldn't reasonably think it's about them. The statement fails the identity test. The last one is Newsweek versus IAC. This is about the case company Newsweek case and MVRS, the group functionally and reading. This is looks like a reference to a specific case involving Newsweek and IAC Interactive Corp. The most cited one is a 2013 defamation suit where IAC sued Newsweek over an article about online dating scams. It wasn't a group libel case, but it's often studied for how hard it is to prove defamation against media companies post Sullivan. Example, IAC claims a Newsweek article falsely linked its dating site to fraud the case. Settled but illustrate that even name companies face a high but they must prove falsehood, harm, fault for a group it would be even harder.
Propriety of class suit. A class suit is improper when the interest of each member is separate and distinct. Reputation is personal. Every Muslim has a different standing in the community. One Muslim may find the article blasphemous while another may find it merely ignorant. So, property of class suit. This slide explains that a class suit is not proper when the interests and experiences of the people involved are different from each other. In this case, reputation is personal, so every Muslim may react differently to the article. Some may feel deeply offended and consider it blasphemous, while others may only see it as disrespectful or unimportant. Because of these different reactions, the court believed that one case cannot represent the feelings of the whole group. The chilling effect. The court warned that allowing damages for group libel would lead to a chilling effect on the press. It would encourage a flood of allegation whenever a group or belief is criticized, thereby suppressing the free marketplace of ideas granted by the Constitution. So the chilling effect. This slide explains the chilling effect, which means people may become afraid to speak or publish opinions because they fear being sued. The court warned that allowing group libel cases would lead to many lawsuits whenever a religion or group is criticized. As a result, writers and media companies might avoid sharing opinions or discussion, which could limit freedom of speech and the free exchange of ideas protected by Constitution. Constitutional shield. Article 3, Section 4. No law should be passed abridging the freedom of speech, of expression, or the press. The court emphasized that libel laws must be strictly constructed to avoid infringing upon this paramount constitutional right, especially in matters a public or general concern. So, constitutional shield, this part refers to Article 3, Section 4 of our Constitution, which clearly states that no law should ever be made to limit or stop our freedom to speak, express our thoughts, or share news through the press. The court explained that law about libel must be read and applied very carefully so they never go against this very important right, especially when people talk about or report on matters that concern or affect the general public. Alternative torts. The respondents also invoke Article 26 of the Civil Code, vexing or humiliating an account of religious belief. The SC responds, even for a tort action for emotional distress, there must still be personal identification. The article was a general commentary, not targeted attack on the plaintiffs. Alternative torts. The people who filed the case also use Article 26 of the Civil Code, which protects anyone from being annoyed or shamed because of their religious beliefs. However, the Supreme Court explained that even if a person claims they felt hurt or upset, the statement must clearly point to or name specific individuals. In this case, the article was just a general opinion, or comment was not written to attack or target the people who brought the complaint.
The SC logical summary. Defamation requires a personal injury to reputations. Injury to a large class or Muslims is not an injury to a person. The press must be free to publish even offensive ideas. And lastly, public education, not loose lawsuits, is a remedy for a religious ignorance. The next one is the dissenting view. Justice Antonio Corpo asserted that, arguing that the article was clearly malicious and insulting. Religious defamation can cause an actual harm to a community. And Article 26 says that the Civil Code should provide a remedy when the press crosses the line into blatant religious mockery. The next one is the separate opinion. Justice Jose Vito concurred that noted that while a libel might not exist, the press must still exercise a social responsibility. He suggested that while the law cannot punish general insults, the media should strive for accuracy and respect in a multicultural society. And the K-legal doctrine is the doctrine says that defamation of a large group does not give rise to a cause of action for libel unless the statement specifically targets a identifiable individual. And the reason why the reputation is the individual group injury is too remote and indeterminate.
The next one is impact on media. This case serves as a landmark protection for journalists and columnists. It ensures that general criticism of religions, political groups, or ethnic committees cannot easily be used to harass the media with civil suits for damages. Lessons for practitioners. We have here for lawyers, for press, and for groups. For lawyers, verify individual ascertainability before filing libel suits. For press, be responsible but don't fear litigation for group-based opinion. And last, for groups, use public discourse to correct misinformation instead of courts. This short explainer breaks down the essential elements required to claim defamation, which help clarify why the Supreme Court ultimately ruled that an individual or small council cannot claim personal injury from words directed broadly at a massive and diverse population.
I am going to discuss about the word slander and libel, but first, let me tell you what is defamation. Defamation is a tort that encompasses false statements of fact that harm another's reputation. There are two basic categories of defamation: libel and slander. Libel generally refers to written defamation, while slander refers to oral defamation, though much spoken speech that has a written transcript also falls under the rubric of libel. To be clear, libel can occur in any form of writing. It could be in an official news story, a quickly published blog post, a social media post, or even an internet comment. Similarly, slander can also be through any type of oral communication. It can take the form of television segments, recordings, phone calls, online videos, or in-person statements.
Under Art. 353, Revised Penal Code, RPC, libel refers to a public and malicious imputation of vice or defect, crime, real or imaginary, that can cause the contempt, discredit or dishonor a person.
And for our last slides, we have here the court's final word. The ultimate good can better be reached by a free exchange of ideas, where the best test of truth is the power of the thought to get itself accepted in the competition of the market. By Justice Velocilio.